Hello and good evening. I'm Melisa Idris.
And I'm Sharaad Kuttan.
You're watching Consider This, the show where we want you to consider and then reconsider what you know of the news of the day. Malaysiakini today paid the RM500,000 fine for contempt of court that was imposed by the federal court last Friday over 5 readers' comments on its website. The news portal launched its fundraiser immediately after the sentence was handed down and managed to raise the RM500,000 in less than 5 hours. But what implications will this verdict have on not just Malaysiakini, but the wider media landscape? Malaysiakini CEO Premesh Chandran joins us on the line now. Prem, the final tally of the Malaysiakini Defence Fund has amounted to just under RM750,000. This from 6,527 donors. Now that averages out to be about RM115 per donor. How have you and your team at Kini read this outpouring of support from the public?
Yeah, hi Melissa. I think that we're really amazed about the support and how fast people rallied to Malaysiakini that Friday afternoon. It was a very tough morning to kind of hear the verdict and especially the fine of RM500,000. The prosecution only asked for 200,000, so we presume that it was between what our lawyers asked for and what the prosecution asked for. So hearing a figure of 500,000 really hit us hard. But the way that people came out, the number of messages, and how fast people donated was really, really amazing. Such generosity, especially at during these pandemic times, where I understand a lot of people are under financial stress and difficulties.
Prem, do you think that that since I guess the almost positive note that this ended on, right, the outpouring of support, that the decision by the police to investigate both Stephen and the MP for Klang, Charles Santiago, for sedition with regard to comments made about the verdict, does that put a damper on things? I mean, are you now very concerned about what's going to happen next?
Well, looking at what has happened first with the judiciary and then now, we think that, we're entering election season. There are issues. It's always a time where the government of the day wants a more docile media. So these are all issues playing into the picture. We're not so surprised that there is this round 2 to this affair that Stephen is being investigated for sedition. But let's make it clear, we're not against the judiciary. We never were. We have full respect for the judiciary. We, obviously we don't agree with the decision. There was also a minority dissenting decision, in this case 6-1. And we certainly don't agree with the quantum of the fine. And I think that was what Stephen was voicing out.
On that note about the quantum of the fine, one of the first things that Stephen said, despite him being exonerated of a personal charge of contempt of court, one of the things that he said was, this is an attempt not just to punish us, but to shut us down. And I'm wondering, is that how Malaysiakini is reading it? That this was could have been a body blow to Kini's operations?
Well, it's really hard to understand how the judges concluded that a $500,000 fine was justifiable. So I think you can see from our perspective, we really cooperated with the judiciary on this issue. We apologized unreservedly. We did all we can, and from our perspective, we were following the law laid out in terms of the Communication and Multimedia Act content code. The remarks were not our own. We took down the remarks as soon as we were notified. So we're really doing our best to, work this out. So given the context, we all feel that perhaps the fine was excessive. The judiciary could have taken a more constructive approach to say, look, Malaysiakini, tell us how you would do better. What would you change going forward? So even if we were wrong, I think there was a better way to approach the issue, specifically because this matter has never been tried in Malaysia. And in many parts of the world, it's a very new thing in terms of media and readers' comments in media.
Right. Perhaps you could help us understand some of the complexities of this, because I believe that the comments also came in a rather innocuous news report, as in fact comments can be, put against articles that are a year old or 2 years old. And the expectation that editors and owners of media must be vigilant in all these areas clearly was something that you felt was unreasonable. But how would you help the public understand the complexities of operations of media, especially ones that are online?
Well, for the comment section, we have a filter that can detect words, particular words that are not should not be uttered. Vulgarities, things like that are easily to be taken out. But it's really impossible to have an artificial intelligence to tell us whether a statement is defamatory or contempt. That has to be done by a human eye. And we do browse through the comments and see what is not appropriate. But we really rely on other readers flagging comments to say, look, this is not appropriate. This should be taken out. And when someone flags it, then it's easier for us to detect and we can straight act on them. But in this case, the story that we ran was not a major story. It was actually a story by Bernama about the Chief Justice talking about opening up the courts after COVID. It was not a big story. It's nothing that we really paid much attention to. And there were a few comments on that story, which nobody flagged the comments. So we didn't really look at them in detail. We get thousands of comments on our website. If you look at our Facebook pages, even more comments on our Facebook pages. And we're not alone. I mean, if you look at any politician's pages, or even the Facebook page of the chief of police or anybody of authority, you see a lot of comments on those pages. So, we've kind of taken it such that, look, there is comments that, we do our best to moderate it, and we understand the consequences of it. But it's not something that we can do all the time perfectly in some magical way. And that's what the Communication and Multimedia Act has its flag and take down policy, which we adhere to.
Okay, Prem, when you started Malaysiakini with Stephen, I mean, there were clear laws governing print media, but not so. I mean, there was not such clear distinctions made when for new media like news online portals. Now, when the amendment was made to Section 11(4)(a) of the Evidence Act, I believe, in 2012, that faced a lot of backlash, and I understand that you too, were part of that reaction. And was there a sense that this amendment could someday come back and haunt websites like Malaysiakini?
Exactly. If you remember back to 2012, there was a huge outpouring among the internet. Many websites went black. There was an internet blackout day, which Malaysiakini and many other media and other civil society organizations took part, where we all said that, having this amendment to the Act really opens the door to, people who are innocent or publishers who are trying to do their best to be, found guilty under these situations. So it's not new. I mean, we actually, we really campaigned hard for those amendments to be withdrawn. And they were never actually used until, in an active way until today, some 9 years later. So I think that, this is something that we have already alerted the government about, and something should have been done about these amendments much earlier.
All right, Prem, thank you so much for speaking with us on the show. We're going to be speaking and looking at the legal side of the case and the verdict after this. But thank you for sharing your insights with us. We appreciate your time. We're going to take a quick break here on Consider This. We'll be back with more, so stay tuned.
Bila sentuh soal berita, tiada masa untuk tunggu. Kepada anda kami bawakan fakta, susulan dan kupasan yang terkini. Tiada drama dan tiada pengulangan. Usah tunggu lama-lama. AWANI 7.45 lebih awal dari biasa.
Kini berwajah baru.
Ini pula susulan khas pesawat Back Air di Kazakhstan. Pesawat berkenaan dilaporkan tergelincir 2 kali.
notifikasi berita terkini dan navigasi mudah. Podcast dikemas kini dengan berita dan program.
Rebirth, Reformasi, Resistance and Hope.
Serta video tanpa had dengan scroll tanpa henti. Buat turun aplikasi baru Astro AWANI sekarang.
Gagalan Kerajaan Persekutuan tunai janji melaksanakan projek baik pulih sekolah Daif turut diulas Menteri Muda Pendidikan dan Penyelidikan Teknologi Dr. Anwar Rapai.
COVID-19, 2 lagi kes disyaki atau PUI direkodkan di Sarawak.
So hopefully kita akan mendapat kedudukan yang lebih baik di masa-masa akan datang.
Udang geragau atau bubuk dalam bahasa tempatan terkenal sebagai bahan utama dalam pembuatan belacan atau cencaluk.
Amanah di tangan kita. Adat, budaya dan semangat menjadi kesinambungan perpaduan tanah air yang tercinta. Berteraskan adab.
Hi, you're watching Consider This. I'm Melisa Idris. With me is Sharaad Kuttan. Last Friday, the federal court ruled that Malaysiakini was guilty of contempt with regard to 5 readers' comments that were taken down 12 minutes after Kini, 12 minutes within Kini being advised of the questionable content. So now we're going to speak to Malaysiakini's lead counsel, Datuk Malik Imtiaz. Imtiaz, immediately after the court decision, you were quoted in the press as a warning against knee-jerk reactions to the summaries of the judgments. You said that the full grounds of the federal court rulings would have to be studied. So what would you say is your understanding now of how and why the judges arrived at the decisions they did?
Right. Well, situation hasn't really changed. The grounds of judgment haven't been issued yet. So we're still left with just the summaries, which although, are fairly comprehensive, one wonders whether certain aspects may have been left out as not being key. So what I was trying to say was that, it's obviously a disappointing judgment to many. But before we react to it, because as we've seen, there's always the possibility of sedition charges and other things, we should just wait and understand the full extent of the reasoning. So as things stand, it's still where it is.
Yeah, speaking of sedition, Imtiaz, of course, we already have news that Stephen Gunn and the Klang MP Charles Santiago are being investigated for sedition with regard to comments on the verdict. What happens? I mean, what is the Malaysian public to learn from this? Is it that the judiciary is above any kind of criticism? Is it possible that is it not possible to make any comments?
Well, so there are 2 issues there. One is what is contempt, and that's exclusively within the domain of the judiciary. And the other is what is sedition, and that's really a matter of what the Sedition Act provides as being seditious. And as both of you know, we've never been very happy with the way the Sedition Act is framed, and that's why we've campaigned aggressively for it to be repealed. So it's pretty subjective when it comes to the Sedition Act. At least that's my view. And when it comes to contempt, then if you go by what case law there is, there are certain guidelines or certain definitions that we adhere to. And I think it's important to note that what Malaysiakini was cited for contempt for was scandalizing the court, or scandalizing contempt as we call it. Now, some other jurisdictions have already said that maybe not appropriate anymore. I think the UK has taken that position, whereas other jurisdictions like Malaysia still maintain that there's a need for it to ensure the integrity of the institution and to leave it to do what it does as an institution. So that's really the conundrum. And I think that's probably why some quarters are saying that there may be a need to have some sort of legislation to define more specifically what it is that is contempt. I would assume what it is that is seditious. So yes, I think. So sorry. Right, I think Malik, we can. Yeah.
Okay, sorry to interrupt you, but I just wanted to ask you, what do you understand to be then the reason that the fine was more than double, 2.5 times more than what the prosecutors had sought?
Yeah, well, I can only go by what the court ultimately said, because once the court handed down its judgment on liability and said that Malaysiakini was guilty, and I'm happy to say that Stephen was absolved, we then made arguments in mitigation, and we pointed out that from the outset, Malaysiakini had taken a very cooperative stance. We accepted that the words were on their face contemptuous. We tendered an apology for having unwittingly allowed for it to happen. And we even exposed our inner workings to show them how it is that we use these filters and the artificial intelligence and the fact that we didn't moderate comments. So we said all of that, and we said that, we think that the judgment itself is sufficient, or if not, then 30,000, because they have before them all evidence of Malaysiakini's financial record, which obviously is not a for-profit sort of organization as others might be. So when the counter was 200,000, we thought that seemed a bit high. And when the bench came out, they did say that they acknowledged everything that we said in mitigation, and they recognized it, and the fact that this was the first of its kind, the decision. But nonetheless, they felt that because the statements were so scandalous, and because they had concluded that Malaysiakini was guilty, they had to send a clear signal out, and that's how we got the 500,000 imposed. That's all I can say, really, because that's all the court said when pronouncing that amount.
Imtiaz, you have on Twitter, suggested that we need to look at the Evidence Act and Section 114A, and we spoke earlier to Premesh Chandran of Malaysiakini about this as well, and reminding us of the 2012 uproar over the amendments to the Act. Could you help us understand a little more from a legal standpoint the complexities of this Evidence Act and that section of the Evidence Act?
Yeah, I mean, that section is unhappily worded, and I don't think anyone is very happy with it. I can't say the judges themselves are happy with it, because it was introduced to make it easier to sue people who were using blogs, hiding behind them to make statements that were injurious. But the truth of it is, as we've seen from the majority judgment, unfortunately, the way the legislation has been framed, it allows for one view that the majority formed in this case, that as long as the presumption is invoked, you can attribute intention and knowledge. And that's what they said here. They said that we ought to have known. Well, first of all, there was a prima facie case because of the presumption. And secondly, we were not able to rebut that presumption because the truth of it is we should have known better. And if we could have filters to take out certain language, why couldn't we have filters to take out other language? I mean, leave aside the complexities of that. The fact is that presumption was pivotal to the conclusion of the majority. Whereas when you look at the dissenting judgment, what the court said there was, well, yeah, okay, it gives rise to a presumption, but surely that's not enough to actually drive home on a beyond reasonable doubt standard a conclusion that Malaysiakini acted intentionally, which was the linchpin of any contempt finding. And so there we have it. An unhappily drafted provision has allowed for what some are perceiving as being an unfair outcome. And so when I tweeted about it, I said, well, I think the best way to solve this is to get rid of it and go back to basic principles of proof.
Imtiaz, can I ask you about the importance of this verdict? What precedents do you think this could set for future cases? Prem mentioned that this is a case that has never been tried before, and this is one of the setting a precedence here. Can you talk to us about the importance of this verdict?
Sure. As we argued in the federal court, as far as I'm aware, this is the first kind of its decision, I think, anywhere in the common law world. In other jurisdictions, what you do have is a situation where a court might order the removal of an offending item. And if the intermediary then says no, that's contempt. And that's understandable. It's breach of a court order. But as far as I'm aware, it's the first time that a court has found an intermediary liable on the basis that it has. So the implication there is this. The majority formed the view that because we could have exercised some control, and in fact we did because we had a filter that sort of weeded out bad language, therefore it would follow that any platform or any intermediary that has that capability could also be found culpable. So in the arguments, we cited a very recent Indian Supreme Court decision where the primary wrongdoer was found guilty of contempt, but the intermediary, which was Twitter, was not. And the majority said, well, that case was distinguishable. In the summary, it's not clear why. But, that's why I'm saying I'm waiting to read the judgment more fully to see what exactly the distinguishing features were. Because if it comes back to the intermediary having some sort of protective algorithm to make the comments more seemly, weeding out bad language, then I would think that any other intermediary in the same position could also be found culpable, which then means you either start moderating comments, which invites a whole world of pain when it comes to liability for defamation and other things, or you completely block comments, which is then counter-intuitive, and it runs counter to the CMA, the Multimedia Act, which talks about no censorship. And in fact, it then undermines that code of conduct. And significantly, one of the things that the dissenting judgment picked up on, which doesn't seem to have found its way into the summary of the majority view, was that under the Media Act, the Communications and Multimedia Act, compliance with a code of conduct is a complete defense.
Okay.
And that's what he did. Yeah.
Malik Imtiaz, thank you so much for being on the show. We appreciate your insights explaining the legal side of things to us. We're going to take another quick break, but stay tuned to consider this.
Bila sentuh soal berita, tiada masa untuk tunggu. Kepada anda kami bawakan fakta, susulan dan kupasan yang terkini. Tiada drama dan tiada pengulangan. Usah tunggu lama-lama. AWANI 745 lebih awal dari biasa.
Kini berwajah baru.
Ini pula susulan khas pesawat Back Air di Kazakhstan. Pesawat berkenaan dilaporkan tergelincir 2 kali.
Notifikasi berita terkini dan navigasi mudah. Podcast dikemas kini dengan berita dan program.
Rebirth. Thanks so much for staying with us on Consider This. I'm Melisa Idris, with me is Sharaad Kuttan. Let's continue our conversation about the impact of the Malaysiakini verdict on the media and also public opportunity for critical discourse. Gayathry Venkiteswaran is assistant professor at the School of Media, Languages and Cultures at the University of Nottingham, Malaysia. Gaya, thank you for joining us. Now, do you think the recent Malaysiakini verdict will have this chilling effect on Malaysian media, as some quarters have warned?
Hi, Melissa. Hi, Sharaad. I think, this terminology of chilling effect has been up and about quite a lot in the last year, given especially in the context of the change in government, the emergency. And I raise that because I think that when we look at what has happened in the case of Malaysiakini, the impact is, in fact, added on to already a very worrying situation, right? So in this case, where it involves directly the public's ability or the reader's ability to engage with the media on critical issues, I do think that for those outlets that actually have and run active spaces for public comments, which tend to be the online sites that are not necessarily the main media outlets that, as Premesh has said earlier, run a lot on Facebook or other social media platforms. But news sites that engage very extensively with readers on their main websites are quite few. And these also include the various forum pages on niche issues or thematic issues where it's really very, very vibrant. And so, if we broaden our interest area from just looking at politics, for example, and look at other areas as well, clearly there is going to be this burden on operators and managers and administrators of all these websites where all kinds of discussions are happening, to ask whether this is going to have an impact on how they manage their sites, right? I think we do need to keep in mind that, especially given the restrictions to meet and discuss, the online spaces have become actually an essential space for, public sphere, so to speak, right? This is where a lot of people are voicing their concerns on a variety of issues. So clearly there will be that chilling effect, but I don't think that this incident is the only one that will lead to that. I think there has been a range of issues, demonstrated by the government to actually act on critical voices, to act on critical, or criticism against the government as well. So I think it's sort of like it's mounting, the pressure on media outlets and also other platform owners. Yes.
Right, Gaia, because we have, the Clubhouse is probably one of the newest platforms. I think they've already had a room on libel and a rather slander and Clubhouse. But I raise that issue because the media is constantly evolving, and I wonder if the laws in some ways are archaic, or they capture some realities, and when things move on, they fail to do that, or they don't anticipate change, and partly because they don't have very strong grounding in, say, a commitment to democracy or to a commitment to free speech. I mean, what is at the root of our problems when it comes to free speech, do you think, in this country?
Yeah, absolutely. I mean, I think one of we probably stop at the Communications and Multimedia Act as actually being quite a sort of a leader when it comes to technology laws, not just in the region, but also, sort of globally. So it was actually quite forward-thinking in many ways, despite some of the provisions that we think could be better. But I think that is probably the only sort of set of laws that took into account this idea of convergence, the fact that media, the way that media operates will eventually change. But politically, this was not envisaged. And I think there was this, we haven't moved from this mindset of how do we control the media. I mean, we come back to this again and again and again. And it's the legislators who are political creatures who decide on the kind of laws that we have. So aside from the CMA, the other laws and the laws that we've seen since then actually take us back quite far, because it's this, the sense of how are we able to pin down the sources of this expression? How can it be much easier? So, we've been hearing about the Evidence Act, for example, and so refining the law to allow for that kind of provisions to.
Gaia, very quickly, in the last minute we have left, coming back to what you said, just a follow-up on this chilling effect that you mentioned a bit earlier. I'm wondering, for members of the public who are watching, what takeaways would you have for them who still want to participate in critical discourse online? I agree with you, there seems to be a growing demand for the public to speak and to be heard now.
I would probably take off from what Premesh had said earlier. There's actually a lot of opportunities for public to also, moderate ourselves, not self-restraint, but actually to allow for a culture of, civic discourses, and to also, have a much higher stake in the media. So if you trust the media, you want the media, as we've seen in terms of how people have come out in support of Malaysiakini, take that responsibility as well as community of readers, right? I mean, we can have differing views. Some of the views may not be, it could be very lame views. It doesn't matter. These need to be defended as well. But as readers, there's also a level of responsibility that we can have in supporting the media in that process, because that space is also our space, right, as citizens, as readers, and as viewers. So there is actually an opportunity to do that as well.
Gaia, thank you so much for speaking with us tonight. That's all we have for you on this episode of Consider This. But before I leave you, let me remind you to get all the latest news and the latest COVID-19 updates on astroawani.com and the Astro Awani app. Thank you so much for watching. I'm Melisa Idris.
And I'm Sharaad Kuttan, signing off for the evening.
Good night, folks.